Good morning, everyone, and welcome to our webinar today on navigating legal privilege, conflict strategies for in-house counsel. My name is Rebecca Wood, and I'm a practice group leader in LegalVision's dispute and litigation team. Before we get into the webinar, just a couple of quick housekeeping items to cover. So firstly, you'll receive a copy of this recording and the slides in your email. You can submit any questions that you'd like to ask in the chat box, and we'll answer them at the end in our Q&A session. And finally, we'd just love to hear what you thought of this webinar. So please provide us with feedback via the survey after the end of the webinar. So as a result of joining us today, you're going to be eligible for a free consultation with LegalVision to discuss how we can help your in-house team. So if you'd like to take up this opportunity, please leave your contact details in the survey at the end of this webinar. You will have seen that a poll has popped up on your screen. We'd love to hear from you about what your biggest challenges are when trying to claim legal professional privilege as an in-house counsel. So let me know what your thoughts are there. While you're addressing that, I'm just going to talk about what we're covering today in the webinar. So firstly, giving an overview of legal professional privilege and the types of legal professional privilege that you should be aware of, how these types of professional privilege apply for in-house counsel, some practical strategies on how you can make sure that you're maintaining privilege, and then also covering some of the challenges that we can face in making sure that privilege is protected in the digital environment that we work in. We're going to talk about some conflict management strategies, and then I'm going to give you my 10 top tips for maintaining professional privilege and navigating conflicts in your in-house role. Great. So let's start by talking about legal professional privilege. So many of us know that legal professional privilege is more than just a legal concept. It's the fundamental core of essentially the lawyer and client relationship. So by providing a right to refuse to disclose certain communications or information, that allows for open, honest, and comprehensive communications between lawyers and their clients. For in-house counsel, it's particularly important. You often straddle a role of being both a legal advisor and a business consultant. There are no alternative provisions that cater for in-house lawyers in terms of privilege. So for in-house lawyers, we ought to be guided by the general rules that govern legal professional privilege. So today that we're going to be exploring some of those nuances of privilege, and again, share some practical strategies for maintaining privilege in your day-to-day work. Great. Well, look, I can see that there's a pretty even split amongst the different categories in terms of your biggest challenges. And many of you are just here to learn, so that's great. So look, I can see that, understanding privilege, making sure when privilege is protected, and then staying independent seems to be key challenges for you to learn about. And rest assured, this presentation will cover those particular topics, but it just, highlights that you're all aware that, you have a very unique position within your organization. And it's a very nuanced issue that requires constant vigilance and clear communication. So look, I'm not an in-house counsel myself, obviously, but I have worked in secondment roles in-house and worked very closely with a lot of in-house lawyers. So understand there's a lot of complexities around these particular issues. So rest assured, we're going to be diving deeper into a lot of these concepts. But if there is any particular questions that pop up as we navigate these topics, please use the Q&A box. So let's talk about types of legal professional privilege. So legal privilege is a right long recognised by common law and now by statute in New Zealand. So we've got the Evidence Act 2006 that deals with it and identifies, I guess, two key types of legal professional privilege that you'll engage with in your day-to-day work. So firstly, one is legal advice privilege, and that's covered under Section 54, and litigation privilege, which is covered under Section 56. So starting with legal advice privilege, which is probably the type of privilege that you'll encounter most often in your day-to-day work, it will protect confidential communications between lawyers and their clients when those communications are for the purpose of giving and receiving legal advice. So as an example, if someone sends you an email looking for some information about, say, the legal implications of terminating an employee's contract, your response is most likely to be covered by legal advice privilege. However, it might be conversely, if someone emails you to say, do you think it's a good idea that we terminate this employee, and you're just giving some commentary on whether you like this person or not, probably not covered by privilege. Litigation privilege, on the other hand, is a little bit broader and it applies in more specific circumstances. So it covers communications where the communications are generated for the dominant purpose of preparing actual or reasonably anticipated litigation. So this could include, for example, internal reports to assess a company's position in respect of potential litigation, or perhaps documents that or exchanged for the purpose of preparing for or instructing, people to do certain things in respect of getting litigation ready. One key difference to remember is that litigation privilege can extend to communications with third parties. So legal advice privilege, however, will be confined to the lawyer and client communications. So let's delve a little bit deeper into legal advice privilege. Again, as I said earlier, as in-house lawyers, this is the type of privilege that you're probably dealing with most frequently. So the purpose of legal advice privilege is to encourage full and frank disclosure between lawyers and their clients. And the idea is essentially that clients should feel free to share the relevant information with their lawyers without fear that the information might be used against them. So for communication to be protected by legal advice privilege, it must meet three key requirements. So firstly, it must be confidential, and there's an intention that it's a confidential communication. It must be between a lawyer and a client, and it must be clear that the communication is for the purpose of giving or receiving legal advice. Look, it sounds straightforward, but as in-house counsel, I'm sure you know that you can certainly face some unique challenges in trying to maintain privilege. So firstly, there's often a blurry line between the legal and business advice that you might have to give. So often in-house counsel are involved in making business decisions and strategy and operational discussions. So it's clear that what you need to be able to do is distinguish when you're wearing your lawyer hat and your business advisor hat. And then secondly, maintaining independence can also be challenging, particularly when you're employed by the organization that you're advising. So courts have generally held, and acknowledged this challenge, but have generally recognized that in-house lawyers can maintain privilege as long as they're acting in their capacity as legal advisors. So what you want to be doing is making sure that you're very clear in terms of what you're being asked to do and what you're being asked to deliver. Litigation privilege so applies when litigation is in progress or reasonably in prospect. The key test here is that the dominant purpose for the communication must be for the purpose of use or preparing for that litigation. So litigation is much broader than legal advice privilege in two particularly important ways. So firstly, it can actually cover communications with third parties. So that might cover the situation where you've commissioned an expert report in anticipation of litigation. So that report and the communications with the third party might be covered by litigation privilege. It's not limited to communications between lawyers and clients. So internal communications within your organization would be met if they're for the if they fit within that dominant purpose test. Another important point to remember that litigation is just not confined to court proceedings. So it could include tribunal hearings or arbitrations or even investigation sort of proceedings, so like a regulatory investigation. So the test for determining whether or not a party reasonably contemplates being a party to a proceeding is an objective test rather than a subjective test. So now that we've covered the basics in terms of those two types of legal professional privilege that you need to be aware of, let's talk about some of the considerations that are specific to your role as in-house lawyers. So as I mentioned earlier, look, the obvious and biggest challenge is the dual role held by in-house counsel. So you have both legal and non-legal roles and obligations, and sometimes you can act as a legal counsel and as an officer of the company. So you might also be a sort of secretary or a director, and this can certainly make it challenging to maintain privilege. So for this reason, it's really important to understand when legal professional privilege will apply. And legal professional privilege will only apply when you're acting in your legal capacity. So it won't apply if you're acting in some non-legal or commercial or executive capacity. And in some cases, you'll need to demonstrate that you are operating with sufficient independence from your organisation to be considered truly an independent legal advisor. So as many of in-house legal counsel, you're essentially working for your employer. Courts have tended to be very cautious in upholding claims for legal professional privilege, and it can be sometimes a bit more difficult for in-house counsel to satisfy and establish the dominant purpose test if they've got a number of duties and also giving commercial advice at the same time as perhaps delivering legal advice. So while it's an objective assessment to determine whether privilege applies in those particular scenarios, it's a question of fact, and there tends to be a heavier onus on the parties seeking to establish and rely on legal professional privilege. So let's talk about this in a bit more practical sense. So some ways in which you might consider implementing some practices to make sure that you're maintaining privilege in your daily work would be, first and foremost, it's the most obvious, clear labeling. Look, marking privileged documents as privileged and confidential, legal advice, is important, but important to also understand that labeling a document alone is not sufficient for it to be considered privileged. It actually has to be privileged. So where possible, separate legal and business advice into different documents. And this makes it much easier to protect the privileged content that you're producing, particularly if you need to later disclose the business advice. You don't want to also be disclosing and inadvertently waiving privilege, which we can talk about a little bit later. It's important to train the people that work around you and with on privilege. They need to understand when and how they can seek legal advice through proper channels, and then also how they should be treating privileged information. So, for example, they should be knowing if you're getting some legal advice from you, that they shouldn't be then, replying all and CCing and sending it all throughout the organisation. Again, we might talk about this in a little bit more detail when we talk about the challenges in a digital environment. It's important to make sure and implement that you've got document retention policies that also protect privileged information. And this would include guidelines on how to store, share, and then eventually destroy privileged documents. So let's talk about waiver briefly. So privilege can be lost through intentional waiver. So, i.e. deliberately disclosing the privileged information, inadvertent disclosures. So that might be an accidental or unintended privilege waiver of privilege, and an implied waiver. So that might be, where the substance of the legal advice is in issue. So in practice, it means that you need to be really careful about what you disclose, particularly say in negotiations or response to regulatory inquiries, third parties, and also just questions within the business. If you've got concerns, consult an external legal counsel before disclosing any potentially privileged information, particularly when it comes to legal proceedings. So as I mentioned earlier, look, there is so much information being generated and stored just as a result of the digital age that we are now existing in. So, when it comes to email, it's really important to be mindful of who you're copying. Essentially, unnecessary recipients can weaken claims for confidentiality and certainly privilege. So, making sure that you're using, firstly, clear descriptive subject lines that indicates that the subject contains legal advice is a first start. But think about who you're sending this to. Do you need to copy in a whole raft of people within a department? Be mindful that once you've sent it, you kind of lose a little bit of control about then who they might flick the advice onto or copy on or add an additional recipient when they reply. So again, that kind of loops back into that education piece about making sure that when you're, the people that you work with are really understanding of what their obligations are when it comes to privileged information and sharing documents that you might be sending to them. When it comes to maybe, your document management systems, so for example, if you're operating with a cloud storage system, you want to be making sure that you're using secure and access controlled systems, particularly when it comes to storing privileged documents. And you might want to make sure that you're very cautious about who has access rights. You want to be in a position where you're controlling who has access to privileged documents that are saved within the organization's systems. Another thing to think about is with remote work being so common, we need to make sure that we're working in secure environments. So we've got secure communication channels and privacy in your home office settings. You need to be making sure that your internal clients are not printing privileged documents at home and leaving them around. So again, some really good document management protocols within your organization are really important things to implement. And just being generally careful about not leaving confidential documents around or having confidential or privileged conversations in shared living spaces. Finally, it's important to have a plan in place for potential data breaches. We're seeing an increase in data breaches occurring. So, it's really important to know, firstly, what to do if a data breach occurs. Do you have a plan in place on how to manage it and how you'll identify and protect privileged information in the event that there's an attempt or an actual occurrence of an unauthorized access to your organization's systems? So let's talk about some of the challenges of navigating conflicts between your professional responsibilities and your obligations as lawyers. As we've said, you've got dual roles, and in-house lawyers have various professional duties that make it a little bit more challenging to navigate and make decisions about how you should proceed. So firstly, on one hand, we've got the duty to the organization. So it's your employer, and ultimately it's also your client. So you've got a paramount duty to act in the best interests of your employer and client. This will involve maintaining privilege to protect sensitive information. But it's important to remember that the client is the organization itself and not the individuals or executives within the organization. So that's always something that you need to factor in when you're giving advice. Now, we need to balance that responsibility against your professional responsibilities as lawyers. So you've got ethical considerations and obligations under the Lawyers and Conveyancers Act and the rules of conduct and client care. And these involve the duties to the court and to your professional community and to act with integrity. So what do you do when perhaps these dual responsibilities and obligations collide? So we can just do a bit of problem solving through some particular scenarios. So firstly, one scenario might be that you've made a discovery that there's been some misconduct within your organization. this information came to you in privileged communication. So, what do you do? So firstly, you need to identify the facts and the legal implications. You might need to advise the appropriate level of management or the board about the issue. So firstly, you would need to make sure and I guess reflect back on making sure that perhaps commercial advice and legal advice are being separated. So if you're delivering legal advice, make sure that it's going to the right people, make sure that it's clearly identified as being a privileged communication. If your organisation then fails to act on your advice, then you've got to consider what your obligations are for reporting under the rules of conduct and client care. So in some particular extreme cases, you might want to consider whistleblowing provisions, but it's really important to tread carefully in order to not breach your privilege obligations unnecessarily. Another scenario might be where you've involved in litigation and you realize that the company is about to submit evidence to the court that you know is misleading. And again, that this is based on information that you've obtained in the course of being a legal advisor and is privileged. So what do you do? So in that case, your duty to the court is paramount and you can't knowingly allow false evidence to be presented. So practically, it means that the first thing that you need to do is to provide your organisation with advice on the legal and ethical obligations of submitting that evidence. And if they insist on proceeding, you might be in a really difficult position where, for example, you might need to withdraw from the case, potentially from your position. But in that case, your obligation to the court will outweigh the obligations to your employer. It's really difficult. Another scenario might be pressure to waive privilege. So, for example, you might face some pressure from within the organisation to waive privilege for particular business advantages, maybe negotiations, etc. In that situation, you need to take a step back and make sure that your lawyer hat is on and clearly explain the risks of a partial waiver, intentionally including potential loss of privilege over related communications. You might want to consider some and suggest some alternative, alternative strategies without compromising your legal protections in place. In those situations, you might want to seek support from senior management or the board to maintain the appropriate legal safeguards. All of these scenarios are really difficult, and there's often there's no course of action that's not going to be, not challenging. In all of these scenarios, it might be worth reaching out to the ethics committee of the Law Society or even to engage external legal counsel to get some independent legal advice from the that you can present, and that might sort of assist you, I guess add a little bit of weight to your position. And also have a firm that's there to perhaps support you in what you need to do within the organisation. But out of all of these scenarios, there's a few key principles that we need to remember. So clear communication. So always be really clear about your role and the nature of your advice. Document your concerns. So if you identify particular conflicts, document the advice and the response. Escalate when necessary. So don't hesitate to involve senior management or the board if serious issues arise. It's important that you, in your role, have properly advised the organisation on the risks if you think that they're trying to take steps that put the organisation at risk. Seek external legal advice. So in complex situations, consider getting a second opinion from external counsel. And finally, just know your ethical obligations and kind of have a plan in place for what you would do if you're faced with a complex ethical challenge. So before we launch into some of your questions, I want to just cover, I guess, what are my 10 top tips? These are the key things that, I hope that you can walk away with that provides some really practical steps that you can implement to make sure that you're navigating legal professional privilege and some of these complex issues effectively moving forward. So firstly, clearly identify legal advice. So make sure it's always really explicit when you're providing legal advice versus business advice. So use really clear language in this. Be really clear and say, my legal advice on this matter is X, Y, and Z, for example. Label documents, but don't rely on labels. So mark privileged documents as privileged and confidential, legal advice, maybe in red on the top of a document, but always just make sure that it's the content and not labels that determine privilege. Limit distribution of privileged information. So share privileged communication only with those who are in the need to know. Broad distribution chains, so that CCing everyone and their dog can certainly weaken claims for confidentiality. Document the dominant purpose of the communication. So when you're providing legal advice, especially in an email or a memo, you might want to have an introductory statement that really makes it clear what the legal purpose of the communication is at the outset. Separate your legal and business advice. So where possible, provide legal advice in separate documents. This makes it much easier to protect privileged information. So for example, if you're preparing an update to the board, you might want to have a document or a memo that sets out your advice and then have your privileged advice as a separate, perhaps annexure that's clearly marked privilege. So separating out those two key communications. When you're emailing, make sure that, again, that you're applying labeling to the subject lines. When you're sending emails that contain legal advice, be mindful of who you're copying and consider if actually a face-to-face meeting might be more important when discussing sensitive matters. Implement and enforce document retention policies. So have really clear policies on how to store, share, and eventually destroy information, and particularly privileged documents. And make sure that all staff are trained on these policies. So for example, it might be a requirement that these are part of your standard onboarding processes. Stay alert and make sure that you're always thinking about potential waiver of privilege. So be vigilant. Particularly when it comes to negotiations or perhaps regulatory inquiries, and consult with legal counsel before disclosing any documents that you think potentially might be privileged, particularly when it comes to legal proceedings. Make sure that you're managing your digital risks. So make sure that you've got secure, access-controlled systems for storing privileged documents and have protocols in place for working from home and data breaches. And then finally, just navigate conflicts ethically. When faced with conflicts about potentially maintaining privilege and then fulfilling your professional obligations, to make sure that you're prioritizing your own ethical obligations. It's sometimes hard to put yourself first, but it's what you need to do. And really don't hesitate to escalate issues and seek external legal advice when necessary. So look, that really concludes the main part of our webinar. You might find this publication quite useful. It's our General Counsel Toolkit. You can download it there's a copy in the resources tab, or you can scan this QR code to download a copy. It's a really useful document on how general counsels can, drive process within their teams. Like I said, we work with a lot of in-house counsel and get some really positive feedback on how they've implemented this toolkit within their organization. You might be interested in another event that we've got coming up, and that's called Protecting Your Business, Best Practice for Preventing Employee Competitors. And that's coming up on 20 May at 11 a.m. And you can register by following the link provided. Now, we're going to answer your questions shortly, so please take a moment to submit them. But I just want to speak very briefly about LegalVision's desk extension. So look, having spoken and dealt with, hundreds of C-suite and in-house legal counsel, LegalVision understands that in-house lawyers are increasingly being pulled in many directions. So they're required to provide input on business critical and strategic matters at the executive level, but often while managing a really high volume of business as usual needs. This is of course, all managed within an extremely tight budget and an even tighter labour market. So under LegalVision's unique offering, which is our desk extension, we can assist you with your business as usual needs, allowing you to cost effectively increase your bench depth and capability of your team and prioritize business critical matters. So our desk extension lawyers invest heavily upfront with understanding what's important to your business, and essentially work as an extension of your in-house legal function. So if you're interested in finding out a little bit more about how LegalVision's desk extension can help and support your in-house team, please leave your details in the survey at the end of this webinar, and we'd just love to reach out to you and talk about you and your business and potentially how LegalVision can support you. Great. Okay, well, look, now I'm going to address some of your questions. I might just start with a couple of questions that were submitted at the time of registration. So firstly, it is, what is the best way to provide advice without losing privilege? So I won't spend too much time on this because I think we've covered this effectively, or hopefully effectively, in the presentation. But I guess, reflecting back to my top tips, it's clearly labeling all legal advice as privileged and confidential, using separate documents for legal and business advice, limiting distribution, education on the people that work around you on the importance of maintaining privilege, and then being very clear as to when you're wearing your lawyer hat and your business advisor hat. Okay, I've got a question, another pre-submitted question here that was that they have a company secretary that is, let me just see. So can a company secretary have legal privilege if she's a lawyer but hired in the role of legal secretary? So look, I guess it really depends on what capacity that they're acting in. It seems to me, based on the way that the question has been drafted, that they haven't been hired as a legal advisor. So if that's the case, then just because they do have legal qualifications and a practicing certificate, I don't think that means that anything that they're doing will be protected by privilege. Again, we need to kind of come back to what's the dominant purpose of what they're doing. So it would seem that they're operating in an executive function, and so very unlikely that anything that they're doing would be covered by legal professional privilege, because it's not the purpose of their engagement or role within the organisation. Okay. Okay, got a question here. Is it best practice to ask the business not to share legal privilege advice, whether internal or external, further within the business without contacting in-house counsel to avoid waiving? Absolutely. I think that that's a great idea. So again, it comes down to that education piece. And, even in your labeling, you might even want to put something in there, not to be distributed or shared without your proper authorization. So absolutely, and I might add that to one of my top tips for next time. I've got, what is the advantage of legal privilege documents? So look, the advantage of, I guess, making sure that something is properly protected by legal professional privilege means that you don't need to disclose it. So again, it comes down to those core principles of what the purpose of privilege is. And that's to make sure that, our client and their lawyer are free to talk about particular issues or particular legal problems without the fear that they're going to be disclosed. But again, it's really important to make sure that the proper purpose of those communications is to provide legal advice. So then again, coming back to those core principles. I hope that answers the question. Often in-house lawyers ask not to disclose advice because it is legally privileged. This is unhelpful when establishing a contract. How is this worked around? I think sounds like that this might be a bit of a specific scenario. So it might be really useful perhaps if we can engage on this in a little bit more detail. So maybe take up the opportunity for a consultation. But look, understand the challenge is that essentially, you know, as in-house legal advisors, our primary objective is to protect the organization and maintain privilege. So it could be that if you're trying to negotiate the terms of a contract, it can be really difficult to kind of have that, back and forth and negotiation without perhaps revealing the reasons why you're trying to do something in a particular way, because that information is privileged. For in-house lawyers, again, for you need to be mindful, of your obligations. And I think really, and make sure that you're explaining to the people that you're giving the illegal advice to the purpose of what you're trying to achieve, and perhaps delivering them the strategies that they need to continue to negotiate a contract without waiving privilege. And then for the people within that organization, I think that, for your executives and your board, hopefully, that they're mindful that of what your role is within the organization to provide that legal advice. And perhaps, again, maybe having a collaborative discussion about how you can move forward with the contract negotiation without waiving privilege. I hope that's helpful. So I've got a question here, which is fairly specific. I'm an in-house counsel based in Australia, but also covering New Zealand entities of our group. Can I claim privilege in New Zealand despite not being registered as a lawyer? That's a pretty specific question. Look, generally, one of the things, that will protect you if you're a legal advisor is having a practicing certificate. So I assume that you've got a practicing certificate in Australia, and there is certainly a recognition of, of foreign advisors. So I think it would be making sure and checking with the New Zealand Law Society that that you can operate and as a legal counsel and legal advisor in New Zealand with your Australian practicing certificate, which I'm pretty sure you can. And so if you've got a practicing certificate, if you're an in-house counsel, and again, coming back to those core principles, if your role is to deliver legal advice within the organization, then, as long as you're being mindful of your other obligations, then that you should be, privilege should attach to your communications. Okay, similar question. If the in-house lawyer is registered in a different jurisdiction, does the legal professional privilege apply to a New Zealand company? So look, again, I think it's making sure if you've hired an in-house counsel that is not doesn't have a New Zealand practicing certificate, and is admitted as a lawyer in a foreign jurisdiction, then you'd be wanting to make sure that that they can practice as a lawyer under, if they had to in New Zealand. So I think it's probably a question for the Law Society just to make sure that those practicing obligations are covered. Because, one of the things that you would need to be, the first fundamental thing that you would need to establish is that essentially the person that's delivering the legal advice is a qualified lawyer. So look, that is all of the questions. I had another a question which was just an overview of the legal privilege risks and actions for in-house counsel. I hope that I've covered that, so I won't go into it in any more detail. I don't have any more questions, so I hope that you found that the presentation answered your questions, particularly those items that we covered in the poll. So I hope that you're walking away with a good understanding of when privilege applies, how you can stay independent, and then, how you can make sure that privilege is protected in internal documents. And finally, if you're here just to learn something, I hope you've learned something. Look, we might wrap up, but look, I appreciate you taking the time to join me today to talk about privilege. I hope that you've learned something. Again, please take the opportunity to book in with our enterprise team to discuss how we can help and support your business. Thanks very much.